My Lords, I was pleased to attach my name to this amendment in the name of the noble lady Baroness Hamway, but very sorry after the powerful debate that we had in committee that it was still necessary to put this down again. Back in our debate report stage on Amendment 6, the noble lady Baroness Smith of Newnham referred to the long and continuing discussion the noble lady the Minister and Baroness Lister of Buttersert and many others, including myself, had in committee about the many amendments that we sought to have applied to all affected by immigration law, the ruling out of scope of those amendments, and the claims from the Minister that what we were tabling was subsequently discriminatory. That's an argument, however, that cannot, or certainly should not, be applied to this particular amendment, for the situation of Britons married or partnered with Europeans is particular. It can only be said particularly awful. I would say that no one with a non-EU spousal partner could have predicted the onerous and unjustified minimum income requirement applied in 2012. Those are not my adjectives, but those of a High Court judge. But what I would say would be an unreasonably harsh assessment might say, well, they should have known that the rules could change when they made their family arrangements. Yet the many Britons who've been writing to me, and as the noble lady Baroness Hamway said, no doubt many other members of your Lordship's House, who established families in Europe in many cases decades ago, could not conceivably have imagined that the dreadful state of British politics over the past 5 years that's brought us to the current pass. I join the noble lady Baroness Hamway in thanking all of them for taking the time, having the courage to share their circumstances with us in the hope that we can get the government to listen. But rather than make my own arguments, I'm going to, as close as possible, let Jane, a Briton who gave me permission to share her story, speak for herself in your Lordship's House. Jane says, I'm a British citizen resident in Italy since 1993 with my Italian husband and children. I have my widowed mother, aged 76, living alone in the UK. She is fortunately in good health at the present time. However, one must be realistic. In time, she may need extra care. As her only child, I have always reassured my mother with my husband that we would be there to care for her in her later years. But due to the possible outcome of this bill, we are increasingly worried. Like many other Britons who moved to the EU while Britain was a member, I had and expected to keep an almost unfettered right of return to the UK with my family. My mother and I were safe in the knowledge that I could always come back should the need arise. I do not want my mother to have this worry. I would like her to grow old knowing that we can come back to the UK should that need arise. Unless this bill is amended, this right will be removed on March 29, 2022, creating impossible choices for me and thousands of families like mine. The government's answer is that we are given 15 months from the end of transition to return with our families to the UK. This is ignoring the massive practical difficulties of uprooting ourselves from family life and work in our country of residence. I have my own business here in Italy, not to mention my husband's work and our children's education. And there may be no need to do that uprooting. That's the end of Jane's words. I would like to ask the noble lady the Minister if she will personally respond to Jane, tell her what the government's justification is for putting Jane and her family in this situation. The Green Group wholeheartedly offers the support to Baroness Hamway if she chooses to put this to the vote. Thank you, my Lords.